Hello, everyone. I hope you're enjoying the Business Revolution week so far. We're very excited to be bringing this special event to you, and we thank you for your attendance. My name is John Hannon, and I'm an analyst with Culkin Ginsberg. I wanted to run through a few housekeeping items before we jump into the informative roundtable that we've got for you. First, I want to thank our wonderful sponsors and subject matter experts for their continued support. Without them, none of this would be possible, so we're very thankful to them. Second, I'd like to give a disclaimer. The information that you're about to hear in this roundtable discussion is not intended as legal, financial, or advice of any kind, and it may not be used as such. Advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure that this information is up to date as of the date of this roundtable. It is not intended to be a full and exhaustive explanation, nor may you use this information to replace the advice of your own legal counsel. The speakers assume no liability for any verbal mistakes or other errors contained in this roundtable, or for changes that occur in the future that affect anything that's discussed therein. So without further ado, I'm going to hand it over to Mike, and we'll jump right into this informative roundtable. Thank you.
Hello, everyone. This is Mike Ginsberg, President and CEO of Culkin Ginsberg Company. I'm excited to be here today with our carefully selected subject matter experts to really talk about a critical topic, a timely topic, and something that I think we all really need to understand, which is an update on legislative and enforcement efforts at both the federal and state levels. Our panelists, our subject matter experts, will discuss CFPB enforcement actions and their impact on consumer and commercial collections, state regulatory trends and enforcement actions, the FCC's reassigned number database, as well as other pertinent topics. Let me take a moment before I turn the keys to the bus over to Roseanne Anderson and introduce our subject matter experts. I'll start with Roseanne. Roseanne Anderson serves as Ontario Systems Vice President and Chief Compliance Officer. She is responsible for leading Ontario Systems' corporate efforts and response to the CFPB's launch of compliance examinations in the ARM industry. Roseanne's advocacy work on behalf of the credit and collection industry has resulted in landmark legislation and regulation at both the state level and federal level with regards to FDCPA, FCRA, as well as HIPAA. In 2020, and I think she should have earned this a long time ago, she was named Chief Compliance Officer of the Year, large company, by the International Women in Compliance Network. Roseanne, thanks for joining us today, and thanks for running things.
Thank you, Mike. I'm looking forward to today's session because I think the topic of regulatory trends has touched almost every business person, if not consumer, in the entire United States. Not only because we see certain trends have surfaced, for example, privacy in California, security and privacy in the state of New York, but most certainly because of COVID and its impact on the regulatory environment for the collection industry. So with that backdrop, I'd like to kick off this topic, this discussion today with Joanne. I'd love to have you share your insights about some critical and important regulatory trends that you've seen this year.
Roseanne, before she gets started, I wanted you to finish that piece. This is a perfect time for me to introduce our three subject matter experts. Then I'm going to turn it over to Joanne to answer your question.
Okay.
Let me take a moment to do that. Joanne Needleman leads her firm, Clark Hill's Consumer Financial Services Regulatory and Compliance Group, serving as a navigator to her clients seeking advice and guidance in the complex regulatory environment facing the financial services industry. Joanne provides counsel, consultation, litigation services to a wide array of financial institutions, law firms, credit reporting agencies, as well as venture capital firms looking to invest in this space. I'm going to stop there. Joanne, thank you. Before you get started, though, let me introduce John and Michael as well. First, John Bernard. John Bedard is the managing attorney of Bedard Law Group located in Atlanta, Georgia. John represents creditors, asset buyers, debt collectors, helping them stay in compliance with state and federal law. He also manages the nationwide litigation for several collection agencies, and he focuses his litigation practice on FDCPA, TCPA, and FCRA defense. John's practice also focuses on defending regulatory actions, including CFPB investigation. And when he can, prior to coronavirus, I know he was on the plane a lot performing CFPB readiness assessments for the collection industry. John, thanks for joining us today.
Thank you, Mike.
Last but not least, I'll tell you, if you're batting third or fourth, you're batting in the right spot. So we saved you for last year intentionally, although everybody here can bat third or fourth. It's really not an issue. Michael Duvall. Michael is a partner of the law firm of Sessions, Israel, and Shartle.
Chartle.
Thank you.
Chartle.
I butchered that before. I said something different, so thank you for correcting that. Licensed to practice in the state of New York, working predominantly in the areas of consumer litigation, regulatory compliance. Prior to joining the firm that he's with now, had a successful career in financial services, serving as vice president and legal counsel for a global bank headquartered in Buffalo, New York. He's also served as director of compliance for an international collections and BPO company with offices in the US, India, and the United Kingdom. Michael, thank you for joining us today.
Thank you.
Joanne, it's all yours.
Thank you. And my thanks to my co-panelists. Always a pleasure to be with you and talking about these subjects. So the question was, what were the regulatory trends this year? There were many trends, and I don't say them in any particular order of importance, just things that are coming to my mind. I think one of the first things was how aggressive several states were in developing their own kind of regulatory regime, especially when it comes to financial services and, more importantly, consumer finance. We may talk about this a little bit more on the panel later. I mean, look at California. At the beginning of the year, the California legislature had put in for a budget to develop what we call a mini CFPB. Currently, the Department of Business Oversight had vast authority over a variety of financial institutions, but in the budget that they proposed, they would change that to the Department of Financial Protection and Innovation. It would be run by Manny Alvarez. It would cover debt collectors. It would license debt collectors. It would have a huge footprint. COVID happened and everybody thought it would go away, but for whatever reason, California found the money and that agency has launched. And it will be an extremely powerful agency with Richard Cordray in the background guiding Mr. Alvarez. In New York, we've seen DFS really spread its wings and explode and really have a lot of oversight. And again, New York is looking to license debt collectors. I think the issue of, I think it brings to the next topic of licensing. I think you're going to see a lot of states where they don't license collection agencies start to do that. Why? Because of COVID, and all these states need money and need revenue. So I think, the states are important, and, the Bureau was very active this year. I mean, you can say what you want about Director Kraninger, but there were over 30 enforcement actions, which is pretty much on par with what Richard Cordray was doing on a yearly basis. We had the debt collection rule come out. There's been a lot of enforcement, been a lot of supervision. I expect that to continue. And because of COVID and some of the parts of the CARES Act that touch financial services, the Bureau is going to make sure that whether it's a debt collection agency or a bank or a mortgage servicer, they're going to make sure they're going to comply. So it's been an active year, and I think it will continue to be active.
Joanne, just as a quick follow-up with regard to the state licensing trend, do you see that, for the purposes of our audience, do you see that impacting, do they clearly define it as what we think of as a third-party debt collector? Are there any, are they leaning into first party or creditors? Or
it's a really good question, Roseanne, and you have to kind of drill down state by state. In New York, there's such confusion between the New York DCA license and what maybe New York state license will be and how they define what is a debt collector. So I can't answer that because I don't know at this point. Right. I think it's going to be interesting. You raise a good point because I think first parties might, again, states are going to need money. however they draft these pieces of legislation to encompass as many people that they can get fees from, they will do that.
One specific area where we've seen that explode in the licensing arena is the subset for student loan servicers and the licensing requirements at the state level. So quite a few states have passed those requirements as well.
Right. Including New York.
Well, tell us more, Michael, and then I'd love to hear your comments about state trends as well.
Well, with regard to the licensing piece, so there are several states that have come up with not just a state licensing regime, but also state borrower bills of rights. Part of that was, and this is a general theme I think throughout these state regulations, is the idea that the CFPB had somehow abdicated their responsibility to consumers, and states using that as a justification to step into the void. Student loans being a prime example. So you've got licensing requirements, student borrower bills of rights. But in addition to that, we're also seeing the states banding together to come up with their complaint tracking system. So you've now got the multi-states getting together with something very similar to the CFPB's complaint portal. They've recently done their presentation and training on how to go about registering for that system and processing your complaints. For all of the weaknesses of the CFPB complaint portal, I think generally speaking, it's been viewed, at least by the regulators, as a success. We obviously have our concerns with the amount of information that goes in unchecked and unverified. However, the sheer volume of complaints that are processed and the expediency with which the industry has responded to those complaints, I think, are very strong points in favor of that portal, and the states are looking to latch on and get their own version of that in there.
Interesting.
You know, here in Georgia, Mike, I reached out to our own Attorney General's office, who is the primary regulator for the collection industry here in Georgia, to ask them whether or not, notwithstanding the absence of direct regulation of debt collectors here in Georgia in terms of licensing and things like that, we don't have that here, are they still nonetheless going to participate in that state portal? And I haven't gotten an answer back yet, but it still remains to be seen, I think, whether or not states that do not have these, detailed regulatory regimes, whether or not they're nonetheless going to sign on and participate in that program. I think the vision of that tool is that all states will eventually sign on to it. And I do think there's potential for a lot of benefit there if that happens. And so we'll see. I sat through some of their trainings and I did some of those things, and it's a pretty clever system. And hopefully regulators around the country will sign on to it, which is what I know their hope is, because it can really normalize communication between not just the collection industry, but lots of industries and consumers through this tool.
Yeah, one more point. I'm sorry, go ahead.
I was just going to do a follow-up. It strikes me as, I'm trying to get my head around, why is it good that others would sign on? Like, what are the benefits that you see when you say that? I hope other state regulators, even if they don't have a licensing statute or regulation, would sign on.
Well, in my view, when you operate a national business, a nationwide business, having some uniformity and standardization on how you are going to interact with regulators when it comes to responding to disputes, when it comes to dispute intake, when it comes to all that, I think that there's some real economies there, not having to deal with individual separate inbound communication from different AGs all over the country or different regulators all over the country. It really standardizes a communication channel to handle a whole host of communication that's coming from regulators and consumers around the country.
Now that standardization is a dual-edged sword, I think, where it's good in terms of the efficiencies that you gain, and also with the transparency where it's not something that's hidden like Defender. But by the same token, those efficiencies and that transparency is also something that multiple states enjoy. And that, from an industry perspective, is probably not a good thing in terms of states latching on to violations that they might not have otherwise had a concern over.
Fair enough. It allows them to crowdsource their own sort of data when it comes to what consumers are saying around the country. Yeah.
Right, that's kind of what I was wondering about too, is it, you know,
Right. Let me make another point about licensing, though. There has been a push by the Conference of State Banking Regulators, this CSBS, I think it's they're called, to do some sort of a uniform licensing. And I think that's important. And again, as more and more states come into this space and looking to regulate financial services, and of course, in the debt collection industry, having a uniform license and a regime to do that, I think will be really important. And now the Conference of State Banking Regulators is not a governmental agency, it's an association, but they do have a lot of sway. I think they put out some excellent reports. If any of you all want to go on their website, they also have try to streamline supervision, especially on non-banks, which would be debt collection. Most of that was for fintech, but to kind of standardize supervision, enforcement, expectations. I think we're going into that trend. It's just becoming, you know, everything now has a national footprint. I mean, you can be in the basement in Minnesota, you know, as a lender, and you have clients that are in California. So, I mean, everybody's footprint now is so broad. While you're going to have particular licensing, that standardization, I see that as a big trend for 2020.
Yes, yes. And that's one of the genesis of this whole system, so that we don't have states, you know, reinventing the wheel every single time with respect to a particular regulated entity. And so now they can sort of crowdsource information about regulated entities and not duplicate effort over and over and over again. And so it's really, most of its design is to benefit all of the regulators around the country, so that they can use their limited resources in very, very surgical, you know, much more beneficial ways.
you know, flipping that around a bit before we move on to some other topics, let's talk a moment about COVID. The states have been very, very active this year with regard to, you know, exercising their power to, during the state of emergency, much less the national emergency, to provide protections out there for consumers, to protect stimulus money. All sorts of things have happened this past year. Any perspective on whether we've, it's maybe too soon to call in terms of any lessons learned, but what do you think we can expect with regard to the future and some of these regulations? Will they stick? Will they hold? Will they have a remote workforce that's going to be accepted? What do you think? I'll start with Michael.
So I think one of the areas that might stick is with regard to the experiment that we were able to participate in with work at home collectors. So you had a necessary trial by fire with regard to work at home agents. And I think for the most part, it's been successful, both operationally and from a compliance perspective. Most of our agencies have been very happy with the returns that they've seen. And from the regulators' perspective, we haven't seen, knock on wood, any issues with regard to security lapses, and the controls have generally been strong. So I think that is a positive that's come out of this. And in fact, Washington on 3 days ago held a board hearing based on their proposed final rule with regard to a permanent work at home authorization. I think that's generally the trend that we're seeing across the country, with Nevada being one of the holdouts. But for the most part, I think once this Washington rule becomes final, it'll serve as a model for the rest of the country. So I think that's one positive. Even if you're not interested in work at home, to have that flexibility, to have that as an option, I think is important.
Absolutely. Joanne?
Yeah, I agree with Michael. I think Maryland is also looking very critically into this and putting some proposals together. I think that will be a trend. You know, I think from a federal perspective, you know, the CARES Act was kind of lumped together very quickly, and it impacted many agencies, and there was not time to collaborate with those agencies to interpret what they wanted to do. So, you know, in terms of COVID, and I know we're going to talk about credit reporting later, that's a real big issue when it came to COVID. I mean, it kind of loaded how all of a sudden standards that we have known for years about credit reporting all of a sudden changed. We learned a little bit, you know, there was some different proposals. We talked about this before we came on, before we started the podcast. You know, when you talk about stimulus and protecting stimulus, there was also a big issue about how to deliver the stimulus and that how consumers were going to get it. There was no discussion about that. It was like, okay, we're going to give them money. Well, they can't go to the bank, and where are they going to deposit a check? These are these are unfortunate consumers. Many are unbanked. So how are they going? A lot of them had to wait for a check, which was 3-4 weeks. So there was a whole issue about electronic transfer, electronic funds. The EFTA was not set up to deal with COVID. And so I think that there's going to be, there could definitely be an analysis, either for the next pandemic or moving forward, how we serve the underbank electronically. I think there's going to be a huge discussion about that.
Great comment. John?
We've seen a lot of good movement when it comes to sort of the regulatory regime, specifically with respect to the work at home that Mike was just talking about, how we're dealing with the under and unbanked consumers. But there's another side to this regulatory coin that I think is, we'll call it less flattering for the regulatory environment, which is really sort of what gets me sort of upset and sometimes excited, which is we have seen throughout the country regulators, albeit with benevolent intent, go too far, right? And we see the on again, off again, you're not allowed to make calls in Louisiana. We've seen, complete prohibitions on communications in some places, the complete shutdown of the collection industry in some other places. We saw Massachusetts overstep and then get sort of, smacked back a little bit. And I do think it's important that we all keep in mind that notwithstanding some of the good things and perhaps even the benevolent intent that our regulators have, it's important that none of us allow regulators to go too far, because a little bit today, a little bit tomorrow, a little bit next week ends up being a whole long distance 6 months from now, a year from now. And we have to be very careful that the protections that are built into our systems are not overstepped or abused by the people who are in charge.
Great comment. Fascinating conversation. The only perspective I wanted to add is that in addition to the fact that we need to be zealous about our advocacy at all of these various state levels and before regulators, et cetera, for the very reasons you're all mentioning. But I also find it interesting that for the first time, I think debt collectors, I think the states have realized that they are humans too. Because when you think about a lot of these work from home requirements, while we're talking about it in the vein of regulation and licensing, and they're all really wringing their hands, how do we, are those branch offices or not? But on the other hand, these people are there because they need protection. They need protection from the same virus that all the other consumers running around need. So it'll be interesting to see for me if when the physical safety health need for the work from home environment subsides, assuming it will the trends that we're seeing, at least for the first time in Washington, continue? It remains to be seen. Now we're going to move on to a completely different topic. And I think we'll just touch on it ever so briefly, but I do think that people in our industry are bombarded right now with tech companies in a good way, but nonetheless about using artificial intelligence, creating algorithms to predict consumers' behavior, preferences, biases, attitudes, you name it, about debt, about income, about spending, and certainly to create a lift. It's all really motivated by, I think it's motivated by two things. I think the use of artificial intelligence is largely motivated by business, and in particular in our industry, to be more efficient. But there is a level on the creditor side, certainly, and on the healthcare provider side, to improve consumer and patient engagement. So with that backdrop, let's talk a little bit about the Equal Credit Opportunity Act, Regulation B, and how that may touch or impact the use of artificial intelligence. Any one of you can chime in and begin.
Well, I'll start just because we have a little bit of experience with this in terms of an analogous situation where, and it may not seem analogous at first, but with regard to credit scoring. And the whole issue behind AI and credit scoring is what is underneath the surface in the programming for each of those. So long as you don't have any discriminatory basis put into the underlying assumptions of that programming, I think generally speaking from an ECOA or Reg B perspective, you'll probably be okay. And just for our listeners who may not have been exposed to Reg B yet, that's the regulation that prohibits discrimination in any aspect of a credit transaction based on a prohibited basis. So we're talking your traditional protected classes of race, color, religion, national origin, sex, marital status, age, receipt of public assistance, or Consumer Credit Protection Act. So long as that AI doesn't take into factors like where do you live and offering up more beneficial terms in one area versus another, I think you're probably okay with that, but this is so bleeding edge that I haven't seen much by way of challenges to it to this point to really say where it's ultimately going to land.
I haven't either. I know that there is there's no need to prove intent. Intent really doesn't matter when it comes to discriminatory practices under the ECOA or Reg B. But John, do you want to talk a little bit about inherent bias or any other observations you have?
You know, when I think about discrimination, I don't get myself concerned much about clients who might be going out and using forbidden criteria to make decisions about their behavior. The thing that I worry about is that facially neutral, benign policy or code that results in some kind of a discriminatory outcome. Notwithstanding that you had a facially neutral, benign input, the output still has this outcome, which now, for reasons that we might not be able to initially explain, has what appears to be an impact on a certain protected class, which is uneven or say unfair. And those are the things that I think about, especially when I think about AI and things like that, which I know like this much about. In my next life, I do want to know a lot more about it because I think it's really kind of cool.
Fascinating. It's fascinating.
But you know, there are people who are building computers that learn from data and its own behavior, and to the extent it learns something that might have been facially neutral but causes this undesirable result, it's almost as if we have to have systems and controls in place to be measuring outcome just so that we can be conscious of the fact that our machines might be generating an outcome that we might not desire.
Or ever intended.
Right.
John said exactly what I wanted to say, and he's 100% right. I recently did a webinar for consumer bankers on AI, because as you mentioned, Roseanne, lenders are really fascinated by this. This is a streamlined process. You get from A to B in a lot quicker way than you would before. But as John says, it's about, I kept saying that, it's about outcomes. And so, you know, you can do all the right things to get to the outcome. You are constantly, it doesn't alleviate you. I basically, what I said is your workforce is going to change. So instead of having people who are going to input data, you're going to need more analysts. You're going to need more people to look and see, you know, what happened. And you're going to have to do it on a really consistent basis. Disparate impact and all of that, the case on that is terrible. You know, it's, as John said, it's all facially neutral. And it's backward looking, and it's stuff that you have no control over, but you have to analyze it properly to make sure there's no discriminatory impact on that. And it has been applied through, not legally, but we are all familiar with publications like ProPublica and some of the other you know, advocacy, social justice type groups. They've talked about this in the debt collection space all the time. Why are you only going after people in the suburb of St. Louis who are really poor, who owe their utility bills? I mean, you know, as we move along into 2021, and if there is, you know, change of initiatives, we really need to start thinking about that. I wouldn't say it falls under ECOA, but I think it falls under the broad issue of discrimination. And I think that is going to be a big issue for the industry.
I do too, and I know I'm not really a panelist, but I did want to throw in for some reason this issue really resonates with me. I think because maybe like John, I'm just so fascinated with the fact that data can lead you to a place you never intended. One of those places might be all of this, the new requirements surrounding limited English proficiency, a well-intended requirement, but to me, I mean, I think the testing behind it is going to be extremely important, because if your workflow, if your treatment of the people who have raised their hand because they are saying, I am of limited English proficiency, easy to say, I think that you could start to see where some Reg B and ECOA impacts could surface unintentionally.
Yep.
I also think that I've been in conversations where people would say, oh, we just love this idea. We have this group of these consumers, and we think they would like to talk to females on the floor. Or we think, worse yet, we think they would like to talk to these white males. They're kind of got a lot in common with each other. Well, you probably know where I'm going with this. It might be one thing under ECOA that maybe you're okay on the outside in terms of your treatment of these consumers. I don't know, that's one analysis. But now you have to look in-house at employment law issues. What are you giving all the big accounts to just so-and-sos who are in a certain type of class? I mean, the internal impact in the workforce could be significant. So I just wanted to mention a couple of those things, because I don't even think we know what we can't know what we don't know, but we have to go into it with, you know, open eyes.
Mhm.
So let's take a look at, Michael brought up credit reporting. That's a nice segue into credit reporting. There is not a defense lawyer or compliance attorney that I can speak with in this industry who does not mention credit reporting in some way, shape, or form as being a hot issue in terms of litigation and compliance risk. So Michael, do you want to kick off this part of our discussion?
Sure. So there's really two ends to it. If you're a data furnisher, you have a host of compliance issues you need to be concerned with. And if you are using those credit reports, you have another list of compliance issues you need to be concerned with. But with regard to data furnishers, the biggest issues we see are really in two specific areas. And the most common, and this comes up both in private causes of action, regulatory enforcement actions, and CFPB supervisory exams. It's what is your dispute handling procedure, and what are your programming factors for date of first delinquency. We see that the most common, and it's almost always for our data furnishers an issue that they need to address and is identified in their final report. And in fact, I think, I may be mistaken on this, but I'm fairly certain every quarterly supervisory highlight report from the CFPB has mentioned one, if not both of those issues.
Right.
And it's hard because of the volume you're dealing with the dispute investigations and what constitutes a reasonable investigation, which is a scalable standard and has to be. If all the consumer says to you is not mine, your investigation is much less than if they send you a police report and indicate that they were the victim of fraud. So those are the two big issues we see, and making sure, and this is a practice pointer for the agencies out there, it's not a revenue generator, but it is a revenue liability if you're not staffed appropriately to handle those dispute investigations. That can really come back to bite you, and has for a number of agencies.
In a few sentences, Michael, and then we're going to move on. I'm going to go to John and then Joanne. But, you know, I've been around in this industry for a very long time. And one thing I cannot understand is, why is it so hard to understand date of delinquency? I swear to heavens that people just can't get that clear in their head. Have you found that? Do you have any observations about that yourself?
I think part of that is a function of we don't get perfect information from our clients. So that doesn't help things. And then you've got issues with regard to different product lines. So if it's something that isn't invoiced regularly, what's the date of delinquency? That can be a potential issue. You've got issues regarding clients treating it differently. If the consumer is brought current, then falls a little bit delinquent. It just, it becomes complicated with the flow of information back and forth, I think. But that's not an excuse. It shouldn't be, to your point, it should not be as complicated as it is, but it is.
It is. It does seem to be. John?
You know, I do also see that issue over and over again, this date of delinquency. But to add to two other things that we've been seeing in the market, in addition to the things that Mike mentioned, was special focus on identity theft and what processes and procedures furnishers have to recognize and to handle properly identity theft reports, to identify when they did get a proper identity theft report and then what they do about it, and how they go about investigating identity itself. That's a focus that we've seen. The other focus that we've seen from a regulatory perspective is focus on the policies and procedures. You know, the rule is that you are required to have policies and procedures which contain certain things. And the regulation, actually, Appendix E to the regulation, actually is an index to all the things you're supposed to have in your policies and procedures. And it's so easy for the regulators to accuse a furnisher of having violated the law because they don't have policies and procedures that contain the required ingredients of policies and procedures. And so, you know, it's almost like a one-off. It's like right out of the gate, you violated the law because your policies and procedures don't meet the standard. And then we go on to, you know, find all these other things that might be wrong. And so those are the two things that I've seen a real focus on as well, in addition to all of the things that Mike mentioned earlier, because those are the hot things that we're seeing right now in credit reporting.
I suppose I'll go on to Joanne here, but I suppose in a perfect world, you not only have a clearly, appropriately, accurately drafted policy and procedure on credit reporting practices, dispute investigation, whether it's e-Oscar or direct from the consumer, but then you should probably follow it. I mean, that's
and not only follow it, Roseanne, but you have to be able to demonstrate that you did follow it, right? And so with all of these controls and with all this auditing processes to say, look, not only do we talk the talk, here's how we know we walk the walk, because here's our audit. This is how we know we do what we say we do.
Right.
Joanne?
We see a couple different things. A lot of concern about investigating disputes from an FCRA basis as opposed to an FDCPA basis. There's a lot of times where you get an FCRA dispute and you treat it as an FDCPA dispute, and the Bureau is really concerned about that. They think they're two different disputes, and they are under the statute. They are two. So we see a lot of that. We also see, to your point, Roseanne, and what Michael was also talking about, you know, there's a lot that we still don't understand about the FCRA. And sometimes agencies make a call because they don't really, they don't have the right information or the issue is unclear. And sometimes they'll make a call for the benefit of the consumer. And we see this in data delinquency all the time. Sometimes people use the charge-off date. Well, guess what? The charge-off date is beyond, it gives the consumer some more time. But even though, or sometimes they'll delete an account, right? That's the benefit of the consumer. But if you're not following the FCRA to the letter of the law, the CFPB has a real issue with that. Even if at the end of the day, it helps the consumer. So we're seeing a lot of that. I think what you're going to start seeing next year, because of the CARES Act and this horrible provision about accommodations and how we're going to document and report during COVID, we're going to see, there was no playbook for that. People are going to be all over the map about how they did that. And all I can say, and I know John's been in a zillion webinars, as is Michael, whatever you did about credit reporting during COVID, not only should you document it 10 times, and make sure you had meetings about it, and make sure that there was a both the communication up to the board and back about how you arrived at this decision to credit report in this way, because it's going to be all over the map. And I think that's going to be concerning for a lot of people about credit.
I've got a couple of cents to throw in on this one too.
Please do.
With regard to the CARES Act, I think our audience should just, if you are a creditor and you made an accommodation under the CARES Act, then you credit report and using Metro 2 in one way. But then if you're collecting charged off debt, it's a different standard. So when the two of you are talking to each other, creditor and third-party debt collector, and you're both talking about responsibilities as a data furnisher under the CARES Act, you're not going to come up with the same answer. Right. So that's one explanation. Something I wanted to highlight. The other thing that we won't go into it at this time in detail. However, we've all been talking about the final rule for debt collection, Regulation F. I think we're at our 1 week anniversary. Not final, but ruined my Halloween.
We still haven't slept yet.
Everyone. So boo. So what I wanted to say about that is there is and I haven't gone way into this deeply enough, but I noticed that they thought they would the CFPB took the opportunity to address duplicate disputes. And on the one hand, I thought, well, good. Well, I know the industry has been plagued with this duplicate dispute, triple disputes, those credit repair organizations and duping the debt collectors to think that the consumer signed the dispute, except they really didn't sign the dispute, blah, blah, blah. But now we're going to have, I can just predict it, we're going to have debt collectors that are confused about duplicate dispute handling under the FDCPA Reg F and the FCRA. Anybody want to jump in on that one or comment?
Yep.
Nope.
Well, I'm just going to say this. Under Reg F, even though it's a duplicate dispute, you still have to send out a notice. You're not doing, there's still a process. It's not like you can ignore it.
Right.
There's a process, and you're going to have to continue to do that process. And under the FCRA, you're going to have to continue to comply with duplicate disputes in that respect. So it's two parallel paths that you're going to have to follow if you're credit reporting.
And that's my point. There are two parallel paths, and you have to keep them straight.
You have to keep, and they cannot overlap, and they cannot intersect, and they should be on opposite sides of the building. That probably is
right. Right.
To deal with that. Yeah, absolutely.
Should we move on? Is that enough on that one? I don't know. We've got more good topics here, I think. Let's talk about the Electronic Funds Transfer Act and Regulation E, the regulation that interprets the act itself. This is Regulation E touches debt collectors, creditors, basically anyone nowadays who has a payment portal. You're probably accustomed to the fact that you are inviting, whether it's a patient, whether it's a consumer, whether it's your customer, however you want to refer to the individual, you are inviting them to set up a payment plan. So with that backdrop, what kinds of issues would you like people to be aware of when it comes to the Electronic Funds Transfer Act and Reg E? Should I start with John this time? How about if I go with you?
Sure. The issue that I see most often in the context of Reg E and the Electronic Funds Transfer Act has to do with this thing called a pre-authorized electronic funds transfer. And what that is basically an ACH, anything that's not a credit card, basically. If you are making a transfer of assets from an asset account somewhere else, then you're probably engaged in an electronic funds transfer. It excludes credit cards, it excludes checks, but debit cards and ACHs and wire transfers and EFTs, all those sort of fall under that definition of electronic funds transfer. A pre-authorized electronic funds transfer is one that is authorized in advance to occur at substantially similar intervals. And so there are different consent requirements or authorization requirements with respect to a single electronic funds transfer and a pre-authorized electronic funds transfer. And that's what I see most often be the issue when it comes to compliance, because the authorization requirements with respect to pre-authorized electronic funds transfers require the transferee, or transferor, whoever's initiating the transaction, to actually have authorization by a writing, and it's got to be writing. The authorization has to be by a writing. And in addition to that, a copy of that authorization has to be provided to the consumer. And so when we think about how those rules fit into the context of accepting payments from consumers who set up payment plans, basically, maybe through a website, maybe on the telephone, maybe through an IVR, you know, navigating the by a writing authorization and navigating the copy requirement is the thing that we see clients struggle with most often.
Michael, any comments on this one?
Similar experience. I'll say this on the Reg E exposure. That was absolutely a hot button issue with regard to enforcement under the Cordray administration with the CFPB. They spent a lot of time examining that issue with our clients. We haven't seen that as much lately, and I don't know if that's a function of a lack of focus or just increased compliance on the part of the industry. So I think most of the agencies we work with are aware of that issue and have addressed it. But if you're not aware of that issue and you don't know if you've addressed it, I think you've got a potential issue in that background. And you might be, while we haven't seen that come up much, I think those agencies that are unaware of it have a potential significant issue because of the volume of payments that they're processing.
Mm-hmm. Thank you, Joanne.
Yeah, I agree with Michael on that. There really hasn't been a lot of guidance in that space, but I will say there are aspects to EFTA that we all should look out for, which I think will be more relevant in the coming year. If you are going to do electronic funds transfer, you have to have the ability that if the consumer has a problem, if there was the wrong transfer or there, something happened, they call it, procedures for resolving error resolution. You better make sure that that is available now, especially since so many more people, to your point, Roseanne, are using payment portals, and the idea of paying electronically now, especially in COVID, has become so important. It is really important to make sure that you have someone that is available when there is a error resolution that can physically talk to somebody. That is a requirement under the statute. So you're gonna have to make sure that that is locked up and tight. I think the other thing that always gets people tripped up with EFTA is, while, as John says, you have to have certain disclosures and requirements, and you've got to give consumers information about how these pre-authorized transfers are going to work, there really is no requirement necessarily about cancellation. You can put information about how you want to cancel your pre-authorized transfer in a given month, and you can put that into your disclosures. It's not necessarily required, but I think that regulators are going to look at that because there's going to be so many people struggling right now, and maybe they did a payment plan 4 months ago because they had stimulus money, and that was a good time to deal with that particular account. But as we move into 2021, and if more and more people become unemployed, the economy is kind of shaky, it's going to be people that want to cancel, and how you cancel that, are you doing it in time? Did you capture the cancellation? Did you actually do it? Because if it results in somebody getting an overdraft or getting into a difficult situation, what's the first thing they're going to do? They're going to call Pete Barron. So,
Exactly.
You really have to get that. Might not be mandated per se under the statute. It certainly can do that, but I think you got to think about that.
See, I think you nailed a very important issue. The only thing I would add is there is actually some commentary or direction given in the regulation such that you need to provide the consumer with a notice of cancellation policy. I thought you did, and it can be oral, which means you tell them you need at least 3 days, or it can be written, but I never really pay attention to it because it sounds kind of stupid, because I think you have to tell them that you could do it orally, except we really won't, we'll try to honor it, but we won't really unless you send it in writing, and then do that within 14 days of when you, I don't know. It's like beyond my attention span at this point. But nonetheless, there is, I think you're absolutely right. And what we do know, and this is for sure not addressed in black letter law, so to speak, if you do have a cancellation policy in the sense that you would say, please click here to come back to our website and here's how to cancel, or, you know, click this box, or you can't have, or call us and here are our business hours. I know you have to give them your business hours when you're open, spend line if you want to cancel. What you can't do is say, you know, if you want to cancel this, send us a certified letter. And you know, it's got to be mailed 9 days exactly before. You can't make unreasonable demands on the consumer with regard to cancellation. So,
Right.
I-
And I apologize for being confusing about that, but there's nothing, unlike what we have in the disclosures that says you have to do A, B, and C.
yes.
That says this is how you cancel. And whenever, you know, Michael and John do a lot of FCRA investigations, it's the same thing. Just define reasonable, you know, investigation, define a reasonable cancellation policy. I don't know what that is. And you're right, Roseanne. So didn't mean to confuse the audience, but it's that area is an area that gets people tripped up the most.
I think so too. Go ahead.
Roseanne, with respect to this EFTA thing, I do have one word of caution, and that is the Bureau published a bulletin on EFTA compliance a couple of years ago. You know, they call it a bulletin. I refer to it as rulemaking circumvention memo. And so I think that bulletin is a bit misleading when it talks about how supervision actually was supervising an entity who was obtaining authorization for pre-authorized electronic funds transfers over the telephone.
Mhm.
And then there's a statement in that bulletin that says that, you know, they decided to do nothing about it. You know, they decided not to take action or not to refer to enforcement or whatever the language was. It leads the reader to believe that what the Bureau observed was consistent with the legal requirement. And I think that's just a word of caution that when people are researching the EFTA and they find that bulletin, that the bulletin is exactly what it is, a bulletin. It is not the law. And judges do not have to follow it, and neither do consumers or consumer lawyers.
And guidance is not a rule. We'll
Right.
harp on that for a second, but guidance is not a rule.
That's an excellent point.
There's going to be a new rule on that.
I think the bulletin, it's November 15th, I think of 2017 or 18, going from memory. And it is the pre-authorized electronic funds transfer, recurring electronic transfer guidance document. So you throw in enough if you throw in enough words like pre-authorized and electronic and recurring and funds, you will find that CFR bulletin. Now, thank you so much. That was a great discussion on what I think to be a very relevant and timely topic. I will close with saying that traditionally, I think the industry is they're very much wired to think about payments like this. Oh, hi, Mr. Consumer. Would you like to set up a payment arrangement? Oh, sure. I promise to pay $100 a month for the next 10 months on the 15th day of the month. Oh, okay, thank you, good deal. Or, you know, can we send you a reminder? Yes. What we just discussed, what I just described was not a pre-authorized electronic funds transfer secured payment arrangement. All that was is a promise to pay monthly, hopefully, you know, but there's no real meat to it. Or I should say, no legal requirements associated with it per se. If you start talking about using a bank transfer, like the panelists talked about, or the debit card, and you end up having a person promise to pay, actually what they do is they authorize you to take that money on the 15th day of the month in the amount of $100. That's where you move into Reg E and the EFTA. It's where you get to do something without really talking to them again. So just a kind of very high level overview. Let's move on to new rules. And well, let's just talk about the Telephone Consumer Protection Act in general, and then specifically with regard to a very important case that we're going to have John kick off in a minute. But let's talk about the TCPA and where we're at with that, John. And if you want to lean into that Facebook versus do-good, please do.
Well, you know, we've got some exciting things coming down the pike from the Supreme Court with respect to the TCPA. And that has to do with really what its scope of coverage is going to be. Because in this case, Facebook versus Duguid, the issue that the Supreme Court has agreed to decide is whether the definition of automatic telephone dialing system in the TCPA encompasses any device that can store and automatically call telephone numbers, even if that device does not use a random or sequential number generator. You know, one of the things that defendants of TCPA cases have been really focused on with respect to the application of the TCPA is the fact that they are not using equipment that has the capacity to randomly or sequentially generate telephone numbers. And that has been the subject of considerable debate, not only among litigants, but of judges as well across the country. And so finally, in this case where Facebook sent a communication, I think it was a text message, wasn't it? To somebody who it didn't even intend to communicate with, to verify security, like it's this dual authentication security when you log into Facebook. And lo and behold, they send a text message to somebody who had a reassigned number, and lo and behold, this person gets upset about receiving text messages from Facebook, and apparently they received a bunch more text messages after being told to stop. And so Facebook's defense is, look, we're not using an ATDS, and therefore this regulation does not regulate us. And that case made its way all the way up to the U.S. Supreme Court. And so in December, there's oral argument before the U.S. Supreme Court on what the definition of an automatic telephone dialing system is. Now, if that doesn't get you excited, maybe this will, all right? Because here's the cool thing about it. There are some really heavy-hitting lawyers that are involved in these cases. The first heavy-hitting lawyer
Is it you?
No.
I'm kidding.
I was just about to announce Mike was involved,
I was
and
gonna
it took
say.
all the wind out of that sail. Yep. And so Paul Clement is actually defending Facebook in this case. And if you'll remember, Paul Clement is a previous Solicitor General of the United States, first of all. Second of all, Paul is so highly regarded by the U.S. Supreme Court that Paul was appointed by the U.S. Supreme Court to defend the CFPB's legal position in the Celia law case. And so that's who Facebook hired to promote Facebook's interpretation of the statute. Legal titan, right? A legal titan. On the other side of this case is another legal titan, Brian Garner. Brian Garner quite literally wrote the book on statutory interpretation. And lo and behold, this case is all about statutory interpretation. And Brian is the source of these very, very sound, I'll call them, arguments about how to interpret the law. Now, I think there are some gaps because the briefing is very, very good in these cases. But nonetheless, I get excited about that because these are lawyers that are just like at the top of the game, you know? And so we're going to get some good stuff from the Supreme Court next year on the TCPA.
I know Michael Del Valle in the Sessions Law Firm, you have like an entire practice section, don't you, devoted to the TCPA or something close to it? I'd love to hear your observations as well. John set the perfect stage for this.
Well, with regard to the oral argument that's being heard on December 8th, I just have a little visual aid. One of the reasons why this is so difficult, you would think language is objective and would have certain meanings, and the issue of did the statute require random and sequential capacity or not would be a simple matter. But in one of the briefs that John mentioned, there is, and I don't know if you'll be able to see this at all, but they graphed out the sentence structure of the TCPA, and it looks like an engineering diagram. So I don't know if
they parsed it just like we did in kindergarten and in grammar school. They parsed the sentences.
It is horrible.
Do that? Oh my God, we're all dating ourselves. Yeah, remember that?
It is absolutely horrible. So it's not surprising that this is difficult. And I think even after this decision comes down, we're still going to have the fallout after the Supreme Court rules on it. But I think, and I would assume John and Joanne are probably of the same opinion, that I think the industry is expecting a favorable result with regard to whether or not random capacity is required here, because of the most recent appointments to the court, with Barrett and Kavanaugh both having a history of having narrow opinions with regard to the application of the TCPA. So I think the industry is optimistic about this. It will definitely help with regard to pending FCC rulemaking on the issue. And very clearly, we want the ACA decision to rule the day as opposed to the Marks versus Crunch Fitness decision that John referenced earlier.
Okay, thank you. Joanne? Any
Well, I
to offer?
can't step on the toes of my esteemed colleagues who have done a fantastic job in analyzing this. Let me add just a couple quick points. I mean, we still have to deal with the FCC, and quick, just my opinion, it's just a shame that it's taken this long to have to get the right case up to the Supreme Court to do what the FCC should be doing all along. And that's going to be unfortunate. But the FCC is going to have to come into this, because if that's what the Supreme Court says, then they're going to have to, hopefully that will help in their rulemaking. There is, a rulemaking also going on with the FCC about what exemptions should be under the TCPA per the Trace Act. So all of that is going to have to kind of meld together and see how that's all going to work. And then couple that, again, we're still in the midst of an election. I think it remains to be seen whether Pai will remain as commissioner, because he's not now in the majority. It could be Jessica Rosenworcel. I might be mispronouncing her name. And we all know that she has very, very strong opinions about the TCPA. So getting clarity on what the statute says is critical. Implementing the statute is going to be another thing, and I think we're going to have to pay close attention to that.
Thank you. And this is a perfect segue into our last topic of the day. We're going to talk a little bit about basically not an offshoot, but a related issue to Telephone Consumer Protection Act compliance. And it has to do with reassigned numbers. The whole issue surrounding, are you calling the right person? And do you have to call the person you intended to call because you thought you had their consent or not? I mean, it's a big circle of issues. The FCC stepped in. And Joanne, since you talked about the FCC, if you want to kick this one up, and we'll go to Michael and John as we go around robin here, I'd love to hear your comments about the FCC's database for reassigned numbers.
Yeah, because it kind of reared its ugly head last week while we were all pouring through the rules, because part of determining and verifying one aspect to it, it's not mandatory, it's an or situation, but if you want to verify a consumer's telephone number for purposes of texting and purposes of having best practices and maintaining a bona fide error defense, one way to do that is through through an accurate and reassigned number database. I'm saying it wrong, but something
accurate, complete, I think, something like that.
Completed and accurate database.
Whatever.
What is that? I mean, we've been waiting for this reassigned database for well over a year. And the initial proposal, I think, was concerning because it really didn't tell you that it was reassigned. It just kind of gave you gaps of time to say that if you looked at it and in 30 days the number hadn't been reassigned, okay, now you can use the number. And I might be using the timelines not accurately. But it really wasn't a database. It was a database that was always growing and always changing. So I think we're still waiting for that. And I got some emails the other day and trying to parse through the rule and getting some clarity as to when we can expect this database. And the last I heard is the earliest is maybe next Q3 of 2021. So that's a real wild card. And I don't, I think all of us are kind of putting our eggs in our basket that this reassigned number database would be, the epiphany we've all been waiting for. I am not so sure. I don't want to be pessimistic, but we don't have anything. And if they're working on what they proposed well over a year ago, I have concerns. I have a lot of
Probably well-founded. Michael?
Well, it's interesting, Joanne made reference to Regulation F's reference to the reassigned number database, and that being one of the verification methods for proving that your text message authorization didn't go stale. But the proposed rule that was offered up with regard to the Trace Act exemptions that was published October 1st had an opportunity to make reference to that reassigned number database when it talked about reassigned numbers and an exception if it was transferred within 15 days of the contact. It could have very easily made reference to that reassigned number database there and didn't. Instead, it gave an opt-out if you had a 15-day window. So it sounds like even as recently as October, they hadn't not necessarily much confidence in that reassigned number database, but now October 30th, the end of the month, they do make reference to it. So I'm not sure what to make of it. I'm not optimistic we're going to see it anytime soon, but it is an open issue, as Joanne identified.
Mr. Bedard?
You know, the thing that I worry about most when it comes to this database is the cost. I mean, how much is it going to cost to bump our inventory up against this thing all the time just to make sure that we're, you know, our authorization hasn't been stale? We don't really have a good sense of what that is yet. And, you know, that cost is not going to be insignificant is my suspicion.
Yeah, it probably won't be. The one thing that I hope the industry does not do, members of the industry do not do, is they don't sit there and just keep waiting. And then when it does go live, let's assume that it does. Let's just assume that we are going to someday have a reassigned number database. Then if you've been just sitting there this whole time and you haven't paid attention as an agency to your own data, for example, when did you last talk to the person who was actually associated with this particular mobile number? Because if you don't have any connection between a person and the number and consent or right party contact, the database, you know, it's not magical. You have to submit data to it, and then it tells you if something bad happened. You know what I mean? It was reassigned. Of and in itself, it's not like a phone book, in other words. So I don't know if any of you read it that way, but I think some activity is required now on the part of agencies in organizing their data.
Yeah, that's a good point, Roseanne. This database is not going to provide the first and last name of consumers associated with a telephone number. That's not what this thing's going to be.
No.
And it's going to provide transfer data. You know, has the number been ported? Has the number changed subscriber since the date you feed it? That's going to be going to be what the data is going to give you.
Right. Well, this has been fascinating. Closing comments, anything you'd like to share with our audience, either about predictions for the future, high points of the year, anything on the topic of regulatory action, state or federal? Michael, I'll begin with you. Thank you, by the way, for an excellent participation. I appreciate it.
Yep. Thank you for having me. The thing I'm most excited about is seeing the work at home authorizations. I think that's a model that the states have been traditionally resistant to approve, and the fact that they've had to go through this test case and it has been successful, and they're willing to respond to it. We're seeing regulations faster than I would have expected. I do like that trend in terms of the go forward for the industry.
Okay, very good. John, thank you also for your participation and behind the scenes for always peeling me off the ceiling when I simply did not get a concept through my head. So I appreciate all you've done for the industry and for me. Your comments.
Well, I, like Mike, I remain very optimistic, notwithstanding all this regulation we see, notwithstanding what's going on in the world right now and COVID and all that. I am optimistic about how the industry is still going to survive and prosper soon, very soon, as soon as, you know, Q1, Q2, this too shall pass, and there's a lot to be optimistic about.
Great. And to my dear friend, a kindred spirit, just a powerhouse in your own right, Joanne, thank you.
It's so sweet, Roseanne. I learned from the best.
Anyway.
Square is next to me. I agree with Michael and John. I'm optimistic too. I mean, I think it was just remarkable what this industry did within the period of days of transferring all these businesses to work from home and really succeeding and really I think using the opportunity. I remember John and Roseanne, you were on that very early. Mike, one of your early group webinars, and John saying, we've got such a great opportunity now. Everybody's at home. Everybody's scared.
It's
We're
true.
here to help.
They
And
answer
I
the
think-
phone. It's true.
Answer the phone. There were more communications, inbound communications from consumers to collection agencies in the last 6 to 7 months than ever in our history. And I think people took advantage of that. I think we were I think, John, you may have coined this term, we were the frontline workers of financial services. And we really did a great job. I see tremendous opportunity in 2021, despite, the rule. We all have our comments about it, but I think it does provide us, I'm not going to say clarity, but certainly a roadmap of, what the consumer experience is really going to be about. And I think we are all well positioned. There's been really good investment in the industry, and I think you're all ready to do it. And we'll push forward, and I look forward to having this conversation.
Thank you very much. Mike, thank you for having us. Any closing words?
Yeah, I have just two parting shots here. The first is, my gosh, I listened to you guys, and I cannot emphasize enough to various accounts receivable management companies. I don't care if you're a collection law firm. I don't care if you're a third party or first party bill collector, buying debt, servicing debt, it doesn't matter to me. If you're relying exclusively on your in-house counsel to help navigate these treacherous waters, you're making a huge, colossal, dare I say huge, like Trump would say, huge, mistake, okay? You're putting yourself clearly in harm's way. That's not to suggest your in-house counsel is incompetent, far from it. They wouldn't be inside your offices if they were. They're extremely qualified, extremely capable, but they're limited by their own capabilities. Frankly, they're limited by your own capabilities, right? People tend to look with blinders on in-house at what's going on with your own organizations, but they don't take those blinders off to see what's going on around them, and many times until it's too late. These folks here, these gentlemen and women, are extremely knowledgeable and extremely competent, as you could see by the last hour's worth of emotion that they put into this roundtable. But also, I know this firsthand, and I don't think they're doing this for Mike Ginsberg's benefit. I will tell you firsthand that they make themselves available. Okay? I have seen them make themselves available. They have busy schedules, and they probably charge a large fee, as well they should. And if not, jack your fees up, folks, because you deserve it, okay? And I mean that sincerely. This is money extremely well spent, and frankly speaking, I don't get paid to say that, okay? This is a public service announcement. Be sure to put yourself out of harm's way, protect yourself by surrounding yourself with knowledgeable folks, different perspectives. It won't take them that long to get to the bottom line. Roseanne is right. Last week, about a week ago, Regulation F was presented to the marketplace. And I know where each and every one of these folks spent Halloween. I didn't do it. I don't know if your in-house counsel did it, but I am certain they did it. And that is review some 600 pages of small print, losing their eyesight even more. That's why we wear these things.
Yeah.
And it's not just because of our computers. They did a fantastic job interpreting the rules and putting yourself in out of harm's way and positioning yourself for the long haul. I can't emphasize that enough. The second thing that I want to do is thank each and every one of you. You guys are tremendous. Okay, you are absolutely tremendous in not only what you do, but how you take a critical, dare I say, complicated subject matter, and you interpret it down to the level that schmucks like me can understand what's going on. And I mean that. I have a lot going on, but it's on a broad level. You bring it down to a level that we can only thoroughly understand it. I am hugely appreciative of that. You guys are great. And thank you very much for your time on a Friday, putting this in place in advance of Revolution Week. Thank you.
Hello again. That was a wonderful roundtable, wasn't it? I learned a lot from our wonderful speakers, and I'm sure you did too. Before we finish, I want to quickly go over Q&A. If you asked a question in chat and hasn't been answered already, don't worry, you'll receive a response within 24 hours through email or another similar channel from one of our SMEs. In addition, I highly encourage you to connect with our speakers through the platform. They're extremely knowledgeable and they're super excited to share their knowledge with you. So I definitely encourage that. And feel free to reach out to us too, and to Mike, because I'm sure he'd love to talk with you as well. So once again, thank you for attending the Business Revolution Week, and I hope you have a wonderful day. Thank you.